The clerk will open the court.
Oyez, oyez, oyez. The Honorable Court of Criminal Appeals is now in session.
Call now cause number PD-0624-20, Dallas Shane Curlee versus the State of Texas. You may proceed.
May it please the court. And Mr. Norman, good morning, everybody. My name is Luis Martinez. It's been some time since I've been before this court. I'm very happy to be here again. I got to do my first Zoom oral argument yesterday, so that went all right. I'm hoping that I learned some things yesterday about that. But thank you for the opportunity to be here. This is it's one of those cases that I try to think, well, it's really simple, but it isn't. And so I always try and keep things straight in my head by figuring out what's the easiest way to describe the problem that I'm bringing to the court today. And that is that one size just doesn't fit all when it comes to figuring out whether a playground is a playground for the purposes of the Drug-Free Zone Act. Preliminarily, I think the first thing that has to be noted is that it's a discussion worth having, because the Drug-Free Zone statute itself creates a situation where we have different things that appear to must be proven by the state in order to have a drug-free zone. And it doesn't create the presumptions that would make this argument so much easier for both sides, and I think for the court and any other court in Texas. The first obvious thing is that there's no presumption that can be made for specifically churches here. And I think that's pretty easy to see. I don't think it's ambiguous and I don't think it's vague. The legislature has given us a set of definitions to tell us what a playground is. And without going through all of it, the one thing that's at issue today is whether or not the area in question in this case was indeed open to the public.
How do we determine that, counsel? What do we look to determine whether something is open to the public? How big of a term is that we're supposed to? I mean, if it's not vague, what's the definition of what to open? How do we define the phrase?
I think it's not so much as the definition as the record that must be shown in order to get there. I know the state, for example, in its briefing, has given us a lot of examples of what open to the public is. But I think the one thing that echoes throughout my argument and through the argument that the state is making is it always comes down to the record. This might not be, I had the same question, and I really do hope I answer your question here, but I think we have the tools already available to us. It's really not so much, I mean, open to the public can be defined in various ways that are common to, for example, the state's recommendations to the court. Something is open to the public when it's shown to be open to the public. Let me explain with a little bit about what I mean by that. We have a situation where sometimes things are open to the public and then other parts within that place are not open to the public. We have places that look like they're open to the public, but they're not. We have places that we assume are open to the public and are not. So let me explain what I mean when I say, let's look at the record. And the thing that's gonna be difficult, I think, is going to be figuring out when we apply common sense and common experience versus things that are more like what we would call direct evidence, okay? I would answer your question, Judge, by saying, when we look at what open to the public is, generally we all know that means it's a place that people are allowed to go to for the benefit of whatever is being offered. That's, if, for example, in the state's case, we had a jewelry store. I believe it was the Dominguez case that was cited. They had a jewelry store where you could go and you were invited, it was open to the public to come shop, but not every part of that business was open.
Well, the thing I'm getting at though, counsel, is the more and more you describe this, the more I'm like, seems like the Court of Appeals did exactly what you're saying. They sort of looked at the record and they said, look, there's these fences, but none of them were locked. And so they looked at the record, they relied on the record to determine that it was open to the public. So it seems like you're making the case for the state. I want to know how are we supposed to look at it then from your point of view that shows that this wasn't open to the public?
Well, first, fencing is not dispositive. And you know, I refer to the Ingram case on that. And that's the thing we've got here. We've only got one piece of evidence that either the Court of Appeals focused on and that the state has focused on in its briefing, and that's fencing. The fencing itself is not dispositive to begin with. But then when you look at the kind of, you know, was part of my argument is that they did not analyze the record correctly. And I may not, unfortunately, I may not answer the really big question here is how exactly should you do it? I will tell you what I think should be done. I think you have to show that when you have something that is not on its, well, in every situation, you got to show that something's open to the public. And you can do it by showing that it's publicly owned, for example. That's a good piece of evidence to put in. That might be dispositive if it's public and it meets the other requirements. You might also have a person that testifies, this is how this is used.
Excuse me, Counselor, was the fencing only around this playground equipment, or was there other property that the fence encompassed?
As it was described in the record, I believe it was around the playground area.
Okay, and the church, I'm sure the church, if let's say somebody just decided to go into that church, that would be an establishment open to the public. So couldn't someone that just decided to drive down that day and attend church just go into the playground? Some member of the public?
I think absolutely that's true, Judge. But then again, I also want to say the church is open for, I mean, it's been said so many different ways, but it's open for the purpose of prayer and meditation and things like that. And sure, you can go in, but that doesn't mean that everything else is then open to the public as well. And accessibility, I think, and that's something that the state has kind of raised, is that, well, Mr. Martinez is focused on accessibility. I'm actually not. My argument's a little bit deeper than that. My argument is that it's not just that something's accessible, because I also don't think that's the end of the story when it comes to proving whether something is open to the public, because then you just have to worry about how many different ways can I try to keep people out, and then how many different ways can people try to get around what I say is going to keep them out. Okay. You know, the other thing is, I think there's a wrinkle there, which is, what is the purpose of the church being open to the public for? Is it for a playground? Because I think that leads to that. And before I get too far ahead of myself, I'm sorry.
Sorry to interrupt, but I have a question. Okay. I just want to make sure I understand what I believe your argument is. So I believe your argument is not that this playground was necessarily closed to the public. It may very well have been open to the public, but I believe your argument is really more the state didn't meet its burden of proof to prove the statutory definition. Is that your argument?
That's exactly my argument, Judge. Okay. Is that I don't, and I appreciate the question very much, because I think that crystallizes what I'm trying to say, is that—
Mr. Martinez, what do you say though about the police officer's testimony and the states that, or I think you say it's conclusory, but he did testify that it was open to the public. Does that carry no weight in a sufficiency analysis?
I think we have to determine what kind of weight and how much weight we would give to that. And I would say no weight. And let me explain why. I think I completely understand your question, and I've addressed it in my briefing, but I've done that's something that's in the record. And I understand legal sufficiency. So I spent a little time thinking about it. Here's what I believe. Regardless of whether it was conclusory or not, and the state said, well, there was no objection, so it's in the record. Well, I understand that. And that's just something I have to deal with. But when you look at the record, and I think going back to Judge Slaughter's question, when you look at the record, what he's saying is not being supported by his investigation or by his experience. Let me contrast or compare a little bit. In, I believe it was the Graves case, part of the facts were that not only was the word park used, so there was the word park, okay, but they used that with a legal definition. Having, I think there was other evidence in that record, perhaps was the Ingram case where they said, and there was testimony, I believe it was the Graves case, there was testimony where the officers had observed the usage of that particular place that was termed a park, okay? So in that case, in the Dominguez case, in the Nichols case, you have these things that are also found at the end of those opinions that say, sometimes it is, but sometimes it isn't, okay? And with
here, don't we also have here photographs of the actual playground and the fencing that surrounded it?
Yes, Your Honor.
Well, I'm just suggesting that perhaps, you know, with the court's ability to look at the photographs, we can assess the reliability of that claim that the officer made that the playground was open to the public for ourselves, just like we would in, for example, if there was a case where a police officer had testified, you know, it was a female who with black hair who shot somebody within my view, and then there's a videotape of it, and it turns out it's a male with blonde hair who's doing the shooting on the video. We can assess that testimony in light of the videotape evidence that, you know, demonstrates otherwise.
Certainly you can, but I would say that, but just to add to that, Your Honor, I would say that sometimes the pictures aren't giving you the whole picture. That's what I'm talking about. Again, we have to look at what the record is, and I want to answer both of your questions with, I think, this answer. It's that you have to look at what Investigator Schmeckel had to say. He says, oh, this is a playground. Is it open to the public? Yes, it is. That basically said, yes, it's open to the public. But you have to look at what does the record contain to show how he knows that. What did he in fact investigate? We know he looked at fences, but there was no testimony that he's observed the area before. He knows it to be, and that didn't.
Isn't that all the proper subject of cross-examination?
Yes. It could be, absolutely. I didn't try the case, so, and you know, with the ability to jet into the future to where I am, I think I understand. But cross-examination, why? But he has no burden of proof,
Right.
Your Honor. And I think again, what I wanted to come back to is, you know, well, we did not have the burden of proof, so we didn't have to try and disprove that it was a playground. That's the one thing. It could have been that certainly any question could have been asked, but I'm sure there was a strategy for that. Getting back to your question, Judge, I think what it comes down to is you have to look at what actually supported that conclusion. For example, and I know this is an absurd analogy, but let's say we have a officer that gets up and says, yeah, I know that guy, and he's a thief. He stole this. And there's nothing else. That's just, you had well, I looked into this case and that guy's a thief. He stole this property. And that was it. Well, I see the smiles on some of your faces. I hope it's in recognition of the point I'm making and not because you think it's foolish. It is absurd. We wouldn't have a problem looking at that kind of case and saying that's insufficient. So,
counsel, so what you're asking us to do is you're saying that the Court of Appeals got it wrong because they just looked at the record wrong, and so we should just look at the record and reach the opposite conclusion and correct their decision, or something more?
I think first what I'm hoping for is I hope that the court will find that there is no presumption that this has to be proven. Open to the public is one of the things that must be proven. To look back at the record and find that there was no evidence to support that, because the focus simply on fencing was not dispositive, and the record does not create anything to support that.
Counsel, you are eating into your rebuttal time. Do you want to save your time for rebuttal?
I do, but I believe that
You're a minute into your rebuttal time.
did you have a question for me, Judge?
No, I wanted you to
Oh,
save your time if you want to.
Yeah, I'll ask my question on rebuttal. That's fine.
thank you, Judge.
Okay. Thank you, counsel.
Mr. Norman? Oh. Oh, there you are. Hi. You're muted, Mr. Norman. Ah,
See, I apologize. Am I coming through now, Your Honor?
yes.
Yeah.
May it please the court, opposing counsel. I think at its core, this case is about common
Counsel?
experience. Beg your
Counsel,
pardon?
would you state your name for the record, please?
Oh, I'm sorry, Doug Norman for the state. At its core, I think this case is about common experience and common expectations. If I could use an analogy, if I drive up to what looks like a convenience store and the door is open and there's no sign either telling me that it's open to the public or that it's closed to the public, that I can't go in. I go in there expecting that I have permission to go into the convenience store. If children walk up to a playground and the playground is easily accessible to them, and there's no sign either telling them you have the right to be here or you don't have the right to be here, the children are going to assume that the playground is open to them.
Well,
And I
so
think-
what, by that, I'm sorry, counsel, but by that analogy, did that mean if I leave my back fence open, kids can come into my backyard and play on my playground that I've set up for my kids?
You know, I think it is context related, Your Honor. I think if it's clearly private property, and here we go with, common expectations. I think we learn to distinguish between, what is obviously private property, like your property, your residential property, and open areas around a church or even public areas, public parks. Most public parks are not labeled as such. They don't say this is a public park and the public has right to be here. It's an open area that when we walk up to it, we recognize it as a public area. It doesn't have any of the attributes.
Counsel, the church would be private property, and here you have a fence around it. So I do think that Judge Newell's hypothetical, is something similar.
I'm sorry, Judge Newell. I tend to, I agree that you have to look at the context, but I think with a church or with a public park, as I believe Judge Hervey mentioned, there's sort of an expectation that you have the right as a member of the public to access that for either worship, if you're an adult, or for play, if you're a child and you're walking by and there's nothing that obviously tells you you can't access this.
But isn't the distinction with a church versus a public park that the church owns that property and they have a right to dictate who comes on, certainly the playground area, versus a public park where anybody can be there. There's no restrictions on that.
I agree that the church has the right to exclude whoever they want to, but I think there's a common expectation, and it all, I think, goes back to common expectations. If there's not a sign there, if the gates are not locked,
Counsel,
I think
counsel, that's a good point. So are you saying that all that the church needs, all that we need is a sign? If there had been a sign, then it's not open to the public.
actually, I'd like to say that's a good argument, but I would not like to foreclose the idea based on things like the attractive nuisance doctrine, that even a sign might not be enough. I think attractive nuisance is actually, even though, it's not maybe a perfect fit, it really does get to the core of what we're getting at here. When children see a playground
But Counselor, we did have evidence. We had the testimony of the officer, right?
Yeah.
Yes, we did.
And
Did
it seems-
the officer testify about whether or not the gates were open or closed or locked or not, or give any sort of reasoning as to why he believed it was open to the public?
Yes, the officer in fact did testify that the gates were open and that one gate in fact was not even capable of being locked off just because of the physical nature of the gate. So yes, there was testimony. And
But counsel, doesn't this seem more like in some ways, a legal conclusion than a factual conclusion? As opposing counsel said, someone testifying to a fact that is actually a legal conclusion, an element that has to be proven. Why isn't this a legal conclusion instead of a factual conclusion?
I think it's mixed, Your Honor.
Okay.
And I think, isn't it normally when we are considering legal sufficiency, we look to see if a jury if there's anything in the record upon which a jury could make a decision on each of the elements. And one of the elements is this, whether or not it's open to the public, and you have evidence of somebody saying, the gate's open, yes, I looked, it was open to the public. And, that might not be a whole lot of evidence. You could say, yes, it was open and there were people swinging on it and there was a priest out there in the middle of them directing activities and motioning to come on in, and you could have all kinds of facts to back it up. But a legal conclusion like that with anything to back it up, it would seem like it's legally sufficient. It might not be enough for you if you were there, but it was enough for the jury, all 12 of them, to say that the person was guilty and that all the allegations in the indictment were true and proved beyond a reasonable doubt to them. And we have to say, no, you were unreasonable in doing that because I would have required more. But I don't think the law does it?
I'm sorry, Judge Walker, did you?
I kind of wanted an answer to mine first before somebody else ask a question. I know Zoom is difficult. It's difficult for me to get in a word, but I did manage to do that. But would you agree with that or not?
Yes, I would agree. And in fact, counsel was making an analogy with, just conclusory testimony about someone being a thief. I'd say one of the distinctions here, and it didn't really, we didn't cite it in the paper, but there was a case out there called Farrow, which talked about shorthand renditions. It's okay for a witness to express an opinion based on all of the things he's seeing at the time and his experience and training as a shorthand rendition of what he's perceiving at the time. And I think this kind of fits into that. You have an officer who, has experience with the area there, who is looking at the area, is taking pictures, is familiar with the area, and is giving you a shorthand rendition. Yes, this is open to the public.
Counsel.
Kind of like saying, isn't it kind of like saying in a DWI, an officer saying he was driving and I looked at him and he was drunk. And that's all. I mean, of course, you could cross-examine all day long and it's a legal conclusion that he was intoxicated, or he could say, yes, he was intoxicated, something like that. But for cross-examination, you could ask more. And a jury might not believe that that was enough to convince them beyond a reasonable doubt, but it's some evidence, isn't it?
I agree, Your Honor.
Counsel, when we're trying to determine what the legislature meant by open to the public, it seems to me that whether the owner of private property can exclude someone from the premises is critical to the determination of whether something is open to the public. Why couldn't we just draw a bright line and say, if the situation is such that the owner of private property could exclude members of the public at his will, then it's not open to the public. And then we'd have a bright line for knowing what's open to the public, not what appears to be open to the public to children in the neighborhood, but what's open to the public.
Well, if I'm understanding your question right, you're saying if the owner could exclude, and then that would mean that there are plenty of places that, the owner maybe didn't exclude people from that would still be considered not open to the public because the owner could have excluded them. I think if the legislature wanted to, they could have written the statute differently and maybe put in there that people have a specific right to be on there, or that the owner has granted them a specific license to. But if you look at the legislative history, and in particular, the legislative history refers to the purposes of the statute, and it wants to cover places where children are known to gather. And I've cited that in my brief. And it doesn't say anything about, children having specific permission to gather. It's what they're trying to do, I think, is protect children who, whether they have permission to or not, they're known to gather there. And they want to create this safe buffer zone where we're going to punish people more specifically, more heavily, if they're doing drugs or doing drug transactions within a certain range of place where children do gather, where children.
Okay, well, that's fair enough, but can you give me some examples of places where a private property that people, you said there are lots of examples of places that are privately owned and could exclude the public but don't. Can you think of some or give me some examples of that?
I would say maybe a closed community where you have closed access, or maybe a homeowners association that has a playground within, an otherwise private community where it is open in the sense that, there are no fences, there's nothing to indicate that children are not allowed there. And, they could exclude children if they wanted to. They
How
could put
about
a
this,
fence
Mr.
around.
Norman? How about this? How about a person that owns a restaurant or, something, but in order to come in, the owner's there and somebody comes in and says, "Excuse me, sir, but I'm not going to let you in here. You're not dressed appropriately." Somebody comes in with a obscene thing on his shirt or something like that and said, "You're really not welcome here." That might be a place that's open to the public, but I think doesn't a restaurant or a owner of a business have a right to exclude certain people that, not on a whim say, "Well, we're not serving people of your race," or that's not appropriate. But sometimes like a dress code or something like that. Are you saying, is it said that, well, when you do that, it's not open to the public? Well, of course it's open to the public. It's just not open to certain members of the public. But if we were to have a rule like, well, if the owner has a right to exclude people, then I think that's a little bit broad. And
it has to be a playground. It has to be a playground with play equipment.
It has to be a playground with 3 pieces of equipment too, is my understanding.
But
If they're stored a slide.
Yeah, but as Judge Keisler said, it could be a Chick-fil-A then, because Chick-fil-A's have the indoor playgrounds. And so are we going to then charge people for possession in a drug-free zone or being in a drug-free zone if they're in the parking lot of Walmart and the Chick-fil-A happens to be within 1,000 feet?
Well, that's certainly open to the public.
I think so.
Yeah.
If I may also, kind of expound a little on the example you gave, Judge Keisler, I think that hits it right on the head there. If you have a restaurant that's open to the public, certainly the owner could turn it into a private club if he wanted to. And he could say, okay, only people that, pay $10,000 a year are allowed to be in my club, and the general public is excluded unless, you go through a review process and you're allowed in my private club. He could do that. But if he doesn't do that, then the restaurant is presumed open to the public.
Yeah.
Mr. Norman, what if there's a house just within 1,000 feet of where this occurs, several houses that don't have fences in the backyard, and they've got a swing set, and they've got a slide, and they've got something else? Are we still dealing with the same thing?
I think you got a much closer case there, Your Honor, and I have to admit that. But, I think the attractive nuisance doctrine, speaks to things like that, because really, even if it's private property, the attractive nuisance doctrine has said that the owner, if it's otherwise accessible to children and if it's attractive to them as a playground would be, then the owner grants them an implicit right to go and play on it, unless there's something indicating they don't have that right and the owner takes steps to prevent them from being there. And I think that's part of the idea.
Wouldn't it surprise people, though, to think that if they have, like this church did, a fence around their playground, to know that a court has said that that's open to the public?
Well, I think there may be a difference between saying generally, okay, it's open to the public and, you can't do anything about it. It's open to the public for purposes of the right of children to come and play there, as opposed to what we're saying, which is it's open to the public as sort of a matter of fact, that it's open in a sense that children will play there and will consider the fact that children are playing there.
But if that were the definition that the legislature wanted, the legislature could have said just places where children commonly gather. They didn't, but they didn't word the statute that way. They said open to the public. So there's got to be a difference between those two things.
Well, yeah, I'm not sure, it may be just a different way of phrasing it, but I think the intent was to capture places where children commonly gather. And maybe they wanted to exclude places where clearly children were not allowed to gather, or clearly the owner had made some indication that they're not allowed to. But I think the legislature intended this to be as broad as possible to cover places where children do gather.
Mr. Norman, I have a question. You mentioned earlier that I think you said at least one of the gates was open. Do you mean it was open, or do you mean it was unlocked?
I mean it was unlocked, Your Honor. Okay. I believe the pictures would speak better than anything I could say, Your Honor, but I do believe it was unlocked. There may have been a latch there. In one of the places, though, the latch was, I believe, because of the physical nature of a wall next to it, you couldn't even latch it. So, you couldn't prevent somebody from just swinging it open without even having to pull the latch up.
Okay, so back to one of the things you said earlier then, about kids and what kids would think and do. Basically, I think you're saying a kid would think, if the gate's not locked, they can go in and play. I think my kids wouldn't have done that. Most kids, I think that if there's a fence around something and it has gates on it and they're shut, that means something. That's a statement. Don't come in here unless you have permission. So
maybe my kids are much more unruly than yours, Your Honor. Mine would have gone in and played.
Okay. Regardless of whether
is there a difference?
I'm sorry. But then you can also take it to adults. Now, forget about the unruly children, because this didn't deal with an unruly child. Don't you think most adults feel like when there's an area that has a fence around it and gates on it and all the gates are closed, that says something that you really shouldn't come in here unless you have permission to do so?
I think that's true, Your Honor, but that's taking it from an adult's perspective. And we're talking about children. We're talking about children who don't, necessarily look at things the same way adults do. And I go back to the attractive nuisance doctrine.
So counsel, as I know you're really excited about the attractive nuisance doctrine, but we're supposed to look at this statute from the perspective of the child rather than the property owner?
No.
Yeah, I think so, in a sense, because you have children out there who are going to make determinations about where they can and can't go. And I think if we look at common expectations and, common experience, and really that's the basis for the attractive nuisance doctrine. I'm not saying apply the attractive nuisance doctrine, but I'm saying it gets to the same basic common experience that we have.
But counsel, with the attractive nuisance doctrine, the fact that there's fencing and around this property would cut against finding it, a liability for attractive nuisance.
I'm not sure, Your Honor, that just the fencing alone would be enough. It's true, it would be a much clearer case if we didn't have fencing. But if the fencing around there, is nevertheless, it's unlocked and it's easily accessible, I think you've still got the attractive nuisance doctrine. You've still got an easily accessible playground that's attractive to children. And it basically, children don't need a sign saying, come on in and play. If it's attractive and they can see it and there's nothing that prevents them from coming onto the property, then they will do that. And
when you boil it all down, the jury had the evidence before it. They have made the finding that, among other things, in finding him guilty, and since that's one of the elements, they have found that it is open to the public. And in order to undo that, don't we have to? No, we'll look at the evidence here, and no, it's not open to the public. Don't we more or less have to say, well, you're just wrong in deciding, looking at all the facts that are before them, the statement, it's open to the public and it's unlocked and accessible and what have you. If they say, yeah, okay, that's open to the public. I mean, wouldn't you say that that you have a jury determination of that? And in order for us to do it, we're just going to have to say, you're just wrong.
I agree, Your Honor. And, I think you have to
we've
look
done
as
that
you-
before, I guess.
I think, as you mentioned, you have to look at the whole thing, and the officer's testimony was open to the public. I don't want to be overstating the case, without the officer's testimony, but I still think there's enough there. And when you look at the legislative intent, that really they wanted to protect against situations like this, and they weren't trying to make, minute property distinctions here about whether the owner gave permission or not. They were trying to protect children.
Mr. Norman, just two questions real quick. Was there a special issue submitted to the jury on whether or not it was open to the public? And what was the impact of that finding? Did it tack on 5 years on top of his sentence, or how did that factor into the sentencing phase?
I wish I could answer that for you off the cuff, but I can't, Your Honor. I'd have to look at the record.
Okay. All right.
Didn't we also take account of a fact finder's authority when making a determination about whether, for example, some fences are made to keep people out and other fences are made to keep people in?
Yes, Your Honor. And I think that goes to the question of what kind of fence this was. Was this really a 4-foot fence like that intended to keep people out? Or was it intended for other purposes? I think the primary intent, if you look at it from a parent's perspective, is protection of the children, to keep them within, at least to have some semblance of restraining them within a closed area where they can safely play. If I'm observing children, if I'm there to protect my children, it gives me a little more comfort to know that they're within an enclosed area that I can keep an eye on, rather than that the whole place is open and I might miss one of them, running out the other side.
Thank you, counsel. Your time is up.
Thank you, Your Honor.
Did you want to start with that? Did you want to start with your question, Your Honor?
No, no, not particularly.
Okay.
I've already forgotten what it was. That's the thing about senility.
you left off, so I wanted to come back.
Okay.
Mr. Martinez, maybe you can answer the question for me. What was the impact of finding that this was a public playground? So we can at least look at the harm that was created. Did it tack on 5 years on top of his sentence, or
I
did it make a minimum of 5?
It changed the minimum to from the call of the judge's note upon the indictment in the record. And I don't have that citation for you, but the judge noted that it was a 7 to 20 punishment range, and Mr. Curlee received a 20-year sentence. I believe it was a $10,000 fine, but I could be mistaken about that.
Well, okay, thanks.
Did that answer your question, Your Honor?
Yes.
Okay.
Well, he had also asked about whether there was a jury submission in this case.
I believe that. I'm sorry, Your Honor, I didn't mean to interrupt you. If I recall correctly, there was a submission, but it was submitted in guilt innocence rather than in punishment.
Special issue?
As far as the drug-free zone.
Okay.
That's my recollection.
Okay.
Well, the record will reflect what it reflects. That's fine.
But I hope my memory is in accord with that. But I think what we've heard, and from the questions that you've all asked, I have to agree with the state on this one point, and it's kind of the thing I'm urging here. It's that this is all context related, and that's why it is important to have a record that answers all of these questions. I know it may seem silly, but when you look at a photograph, or just the myriad of questions we've had about fencing, is it to keep people in or keep people out? I'm from the school of thought as Judge Walker. I see a fence, it tells me don't go in. I taught my kids that, my dad taught me that. But that's not going to be the same for everybody. So there must be context in the record to tell us that. Judge Kiesler asked, well, why should we overturn? I think that's really the heart of your questions to the state. Why should we overturn what the jury decided if there's this evidence in front of them? But that is the nature of any legal sufficiency attack, is that I'm saying that there's something that they heard that they could have made a decision on, but I'm attacking whether that in and of itself is sufficient. For example, I didn't just coyly use an officer calling someone a thief and saying, well, that's a legal conclusion, we're done. There would have
But we
been-
certainly, excuse me, but we certainly don't want a situation where if a defendant has drugs and he sees fencing, but there's fencing around a play area, that's okay, because there's fencing.
And I would say to the prosecutor, I apologize, sorry, Zoom. Did you finish your question? I'm sorry, Judge.
Well, as Judge Erie proposed earlier on, you did have the officer on the stand, and I know you didn't try the case, but cross-examination could have developed whether, this really was a area open to the public or not, but that wasn't done. So you did have some evidence from the stand from the officer.
That's just true. Yes, I agree with you, Judge. However, I will say that being that it's not the burden again of the defense to create that case or disprove that, I'm still saying that the state has to prove this. And I think part of the question is, how do we do this? And I think this may come back to Judge Newell's question originally. How do we do this so that we can keep that situation that you've described from happening? And I think that's pretty simple. You have somebody who knows, and it doesn't necessarily, there are so many different people that could have done that. For example, it could have been an officer who says, I patrol this area. I see kids from the school walk across from school and go into this playground constantly. It could have been a pastor who says, this is regularly used by children in the neighborhood, whether or not, some of them I recognize, some of them I don't. We keep these fences here for this reason. This is why, go ahead.
You very well may be right in your assessment, but then isn't it a fatal flaw to your case, the fact that trial counsel never objected to the introduction of the statement by the officer?
I don't think so, because I still think, unobjected to or not, the court still can look at whether or not it's conclusory, whether or not it is actual evidence, or it's just opinion. Because think about this, without context, without showing why he reached that opinion, without showing, and I mean something, there's an extra specific thing to look at here. His statement is based upon what he saw with fencing, okay? And I do want to raise in one thing.
Counsel, your time is about out, and I wanted to suggest that whatever the officer testified to about it being open to the public, if he had testified that Judge Newell's yard with the back gate open to the play equipment was open to the public, we wouldn't have to defer to that, would we?
I don't think so.
No, it's the same thing with this officer. Okay, go ahead.
By the way, my backyard is not open to the public.
And your time is up. You can have a minute to conclude if you'd like to.
Thank you. I know that this is not easy, and I know what I'm asking the court to do here, but honestly, I think you just have to look at the record. And I think the hard questions really in this case come down to the problems that we've all seen with fencing here and whether that's enough. It isn't. It can't be, because unless you have something in the record to support that, then we're all just kind of speculating. It is context related, but the state failed to provide any context. And that's why I think that the court should rule in our favor here and let us all know in Texas what we need to do next time. And
Thank you,
I'll conclude
counsel.
with that. I appreciate
The case is submitted. The court will stand in recess. The clerk will adjourn the court.
Oh, Oyez, oyez, oyez. The Honorable Court of Criminal Appeals now stands recessed, subject to the call of the presiding judge.